Yeah, uh, we are going to start our international webinar on intellectual property rights, potency, design, and publication ethics. A very good afternoon, everyone from India and from also from abroad, as because this webinar is going to live stream from different Facebook account. So myself, Dr. Shumon Chakraborty from Department of Anthropology, and also the member of IQAC. So it is our immense pleasure to organize this kind of international webinar, and we have the different speakers from India and abroad. Now I would like to hand over this platform to our IQAC coordinator, Dr. Mithali Gangopadhyay. Mithali.
Thank you so much, Shumon, for introducing the program to us. A very, very good afternoon to all of you in this one-day international level webinar entitled Intellectual Property Rights, Patency, Design, and Publication Ethics. The IQAC of our college has engaged itself into a host of academic activities in this long span of COVID-19 pandemic lockdown. We have been constantly collaborating and organizing various online webinars, workshops, FDPs with different departments of our college. In fact, on the last Teachers' Day, that is on the 5th of September, we organized a national workshop on the usefulness and precautions of online class. And you can see today we are here again, back, trying to focus on an issue that is of huge relevance to the academicians and researchers, that is of the intellectual property right. We will be discussing today on a kind of property which is not really tangible, which is not without, but within our own selves, which is our human intellect. It is one of the most expensive properties that we possess, and therefore we must secure it before being stolen, copied, or invaded in any way. And this is where it comes the need of legalizing our right over our own intellectual property. If you turn to the IPR laws, you will see that mainly there are two main purposes. One, to stimulate and to encourage, spur our human intellect to a wide range of creativity and innovation. And the other, of course, is to impose laws to secure and protect that creativity. At the very outset of the webinar, I must express my gratefulness, my gratitude to the Department of Promotion of Industry and Internal Trade, Government of India, for supporting us in this webinar. My heartfelt thanks also to the esteemed speakers of the day, Professor Lowe, Professor Pratap Das, and Sri Shantay Bandyopadhyay. Without their kind consent, I don't think it would have been possible for us to organize this webinar. I'm extremely grateful also to all my team members of IQAC. They have shown immense enthusiasm in organizing and in helping the IQAC collaborate with all other departments. For this particular program, I am really indebted to Dr. Debashish Mollik and Dr. Shumon Chakraborty, two very prestigious and two very important IQAC members who have taken actually the lead to organize this particular program. With this, I would request our very respected principal, sir, Dr. Apurva Bandyopadhyay, to deliver his welcome address. Over to you, sir.
Thank you, madam. Thank you. Hello, everyone. Most welcome to the international webinar on intellectual property rights, patency, design, and publication ethics that has been organized by the Internal Quality Assurance Cell of Mrinalini Datta Mahavidyapeeth, West Bengal, and supported by the Department of Promotion of Industry and Internal Trade, Government of India. It is a pleasant privilege for me to welcome the prospective speakers of today's webinar that has a kind of global importance. To be specific, we feel glad to welcome our first speaker, Sri Sanjay Bandyopadhyay, Deputy Controller of Patents and Designs and Head of Office, Department of Promotion of Industry and Internal Trade. Government of India. Yes. And we are waiting for his inaugural lecture eagerly because Sri Bandyopadhyay maintains prime responsibilities to integrate intellectual property as a policy and strategic tool in national development plans. It is our great pleasure and honor to welcome once again Professor Wa Woon Lo, Deputy Executive Director, Research and Internationalization, Asia-Europe Institute, Professor of Psychology. She is also Professor of Psychology, Faculty of Medicine, University of Malaya, Malaysia. Very recently, we enjoyed her expertise in the International Faculty Development Program of our college, and I am sure that we will be equally enriched today by her invited lecture because Dr. Low has extensive experience in research and publication as well as in administrative activities. We feel sincerely obliged to welcome Professor Pratap Kumar Das, retired scientist, Indian Institute of Chemical Biology, who has long involvement in research on diseases of national importance and biological problems of global interest. Today, the invited lecture of Professor Das on IPR must be enlightening for us because he has also offered substantial attention in developing drugs from indigenous and natural resources like native medicinal plants. I feel overwhelmed to welcome the learned participants of this webinar, most of whom are the dedicated teachers and students from several institutes of higher education. The system of higher education throughout the globe nowadays has felt the requirement that the higher education institute be innovative, creative, and entrepreneurial in their approach. This is possible when we can promote a research culture to generate wide variety of intellectual property, of course intangible, and maintain industry academia innovative practices. It has been advocated that intellectual property rights and the associated laws stimulate creative works and contribute to academic and technological progress of countries. World Intellectual Property Organization, or WIPO, was established in 1967 for fine-tuning the balance between interest of right holders and of users. Absolute protection of intellectual property has been viewed with controversies with respect to the development level of the countries. Stronger patents create market monopolies, thereby restricts further innovation and technology transfer. Rather, diffusion of ideas encourages innovation, protects human rights, and secures public interest in health and other life-sustaining sectors. Today, we sincerely aspire that the eminent speakers of this international webinar will enlighten us over the conceptual and ethical framework of IPR so that we can avoid any legal consequences involved in the process of research or publication, even if we like to participate in the debate on piracy or plagiarism. At the end, I remain thankful to the Department of Promotion of Industry and Internal Trade, Government of India, and to our dedicated members of IQAC for organizing this important webinar. Finally, I wish grand success of this webinar and welcome you all once again. Thank you.
Thank you so much, sir. Thank you for your words of kindness. And as you always do, you strike a keynote to the focal theme of the webinar. Thank you so much, sir, from the very depth of my heart. I shall now request, we will go into the proceedings of the webinar immediately after this. I shall now request Dr. Dilip Kumar Mondol, Department of Education, who is the head of UG and PG Department of Education and an important member of our Internal Quality Assurance Cell, to introduce the first speaker to us. Over to Dr. Dilip Kumar Mondol.
Am I audible?
Yes, yes, you are. You are.
Namaskar. Very good afternoon to respected Srimati Chandima Bhattacharya, Minister in charge, Government of West Bengal, and she is also the President of our governing body. Respected Dr. Apurva Bandhopadhyay, Principal of our college, my beloved colleague, Dr. Mitali Gangopadhyay, Coordinator IQAC of our college, all the members of IQAC, resource persons, participants, other dignitaries, my fellow colleagues, teaching and non-teaching staff of our college, and my dear students. The internal quality assurance cells, Hinalni Datta Mahavidyapit, Irati, West Bengal, India, and the Department of Promotion of Industry and Internal Trade, Government of India, Salt Lake City, Kolkata, India, takes the initiative to organize an international webinar on intellectual property rights, patency, design, and publication ethics. It is my great honor and pleasure to introduce our first speaker, Mr. Sanjay Bhattacharya. He obtained his Bachelor of Electrical Engineering from Jadavpur University in the year 1987. He was a scientific officer, electrical, National Testing House, GOI, Ministry of Consumer Affairs, Food and Public Distribution, Department of Consumer Affairs since 1997 to 2002. Presently, he has been working as a Deputy Controller of Patents and Design, the Patent Office, GOI, MCI, DPIIT, as well as Head of Office, Patent Office, Kolkata, West Bengal, India, since 2002. It is also impossible to mention his every single accomplishment because these are a lot. However, today we are here to recognize Mr. Bhattacharya's outstanding talents on intellectual property rights. It is such an honor for us to have you today within us. Thank you so much for coming and bestowing us with your own presence. Please welcome Mr. Sanjay Bhattacharya.
Thank you. Shall I start now?
Yes, Mr. Bhattacharya.
My regards to all faculty members and organizers of this program, and I'm really thankful to all the participants. In spite of this pandemic situation, they are showing interest on regarding IP. And before coming to the topic, I would like to point out there is one small mistake on my regarding my surname. It has been as instead of Bhattacharya, it has been mentioned as Bandhopadhyay. So I think by mistake it has occurred, and in future we should take more care so that proper surname and name should be mentioned. And now objective now IP is very important. That's why we are organizing this kind of program. And another immediate objective for your institution, perhaps getting the 5 marks, which is given while for attending for organizing this IP seminar. So now seminar is not possible. So through webinar you are organizing this, and hopefully we will get 5 marks while when NAC accreditation will be done. So best of luck for that NAC accreditation. And regarding IP, you see that IP concept was introduced in India from Europe. Actually, in if we go back to our ancient mythology or Indian culture, for us knowledge is free. We are never used to get money by sharing our knowledge. It was Indian philosophy that if you share your knowledge, then it increases. But Western concept, which was introduced in India through Britishers, that is different. For them, knowledge is money. If they can make money out of his knowledge, then only it will be shared. Now, not only in the field of patent, now you see that a lot of industries, they are using foreign technology, and there is some industrial collaboration with different industry, and technology transfer. And for all these things, the Indian counterpart has to make some profit sharing. So that is the Western philosophy, and nowadays it has been established. So if we want to remain and we have to make progress, it is very important for us also. We should gear up on the same line. Now, IP journey in India started long back in 1856. So it is more than 150 years ago. It was started by East India Company in 1856. And now where we stand. Now over this period, recently in the field of patent, we have crossed 50,000 filing mark. That itself a big achievement. When if we compare with our previous filing, it has gone higher in over the years, say last 18-20 years. Rapidly it has grown. But an Indian application out of this 50,000 is only 17,000. Most of the filing are from foreign countries or foreign origin. So we need to increase more and more domestic application. And for that reason, this kind of awareness program is very much essential. And our function of IP office are basically two ways we are functioning. One is giving IP right. That is our basic job. And second one, since although this subject is very old, but awareness in a country of having population of 1.34 billion is very low. Everyone is aware about that IT, but not about IP. Everybody is familiar with 3G, 4G like that. Even some people, they are aware about 5G, and research work is also going on. But the problem is that regarding intellectual property, very few people are aware, even about that faculty members. Their Indian concept is that patent is a very complicated process, so we should not go in that route. Rather, we would do a very good research work and publish it international journal, and we will be get credit for that, and we will be appreciated, and we will be in our field. We will be a renowned personality. But actually, you see that filing of patent application, those learned faculty members and research scholars, they are highly qualified, educated, knowledgeable. It is not a very difficult job to write a patent specification. They, on their own, with their knowledge, since they itself are submitting their research paper, and they are just doing it on their own, so they can very easily, they can also write their patent specification. So that's, but we are having that fear. Fear is affecting just detrimental to this progress in the field of patent. So we should have put some effort, and so that in the coming years we can overcome this fear. And you see that Indian IP system, I just told that it started in 1856. But however, in China, it began in 1856. But now in filing, they are the global leader, and it is in the it is more than 1 million applications in a year, whereas we have just crossed 50,000 mark. So we are way behind to China, but population-wise, we are more or less having same. They are number one. We are just number two. So we can. We have progressed, but we can make further progress. Actually, 6 different IPs are governed by our office. That means Office of the CGPCT. These 6 IPs are patent. Number 1 is patent. Number 2 is industrial design. Number 3 is trademark. Number 4 is geographical indication. Number 5 is software, and number 6 is integrated circuit design. Now each having its own significance. Now you see, for patent is for basically for invention. Now, if we are passing through the age of pandemic, now if someone just can bring some vaccine or medicine for patent, then it is having a very good market prospect, and not only that, it will be very helpful if it is affordable for the general people. Then it will be very helpful for the throughout the world for human beings. So one aspect is that commercial part. Okay, if you can invent something which is very useful or affordable, then you can make good business out of that. But that is not the ultimate thing. Even though it may not, if you are not, even you are not making money. Suppose the scientist or the professor, he invents something which is and his right is going to his or say academic institution, or say in case of scientists it may be CSIR. But there is some arrangement for profit sharing. However, irrespective of that profit, if it helps the human community as a whole, that is a big satisfaction for a human being. So we can that social aspect. Now we are suffering from many other issues like say pollution. Then now cost of fuel is going up day by day. So if we can make some invention in the field of solar energy, and it becomes much more affordable, in that case also we will be benefited. And pollution control, if we can just say waste management technique, if we have a very good, and there is a drive to just remove plastic. So in that field, if some invention comes which can which is affordable and can replace plastic, then that is eco-friendly. That will be very beneficial for our society. So that way we have to think, and we have to tune ourselves so that we can do something, or we can achieve something which will be helpful for us and for this country, and not only for our country, for other parts of the world. So that is basically the patent. And patent, and what about design? In brief, I would like to say that design means here it is industrial design. It is not engineering design. Engineering design is something else. Now you see, I am giving an example. Long back, and he is this year he has expired. Rishi Kapoor. His first movie was Bobby. In that year, there was a particular print. That print is became very popular. It was called Bobby print. In a lot of textiles were sold, garments and textiles were sold with that particular print. This is an example of a design, and this is the impact of a design. Now we go to market and purchase a lot of articles, but we have a budget. But if within our budget, we just choose. We see different items, and out of that, the design which is most attractive, we purchase that. That is the importance of design. And what about trademark? You see, the trademark is that is a creation of brand value. Now, if we go to purchase for shoe, if our budget permits, we go for Bata, Khadim, or say Woodland or Haspapi, like that. Why we go for those brands? Because we are having a concept. Although it is not brand name is for brand identity, but we are having a faith in a particular brand. If it is Bata, then it is good. When we will go for purchasing a car, we will go for branded car. We are not going to buy a car from a company which is new in the field. So we are investing money, and we want to be secure. So that's why this brand value. So brand value is for trademark. And copyright, we all know that literary and artistic works and all these things are coming under copyright. Then it is a geographical indication. Now, geographical indication is also very important for community development. Now, it is this right is given to different people of different community. That is a particular group of people who are involved in that particular trade. They get the right. like Baluchari study. The people who are residing in a particular area and in the business of producing this Baluchari study, they are enjoying the right. And for last is that integrated circuit design. It is purely technical and it is provided for a period of 10 years. And regarding other intellectual properties, they are having fixed term. For patent, it is 20 years. For industrial design, it is initially for 10 years, and after that, it can be extendable for further 5 years. And for trademark, it is initially 10 years, and it can be renewed as long as the company is interested to renew. Similarly, for geographical indication, it is also for initially 10 years, and afterwards it can be renewed for every 10 for next 10 years. And for copyright, in case of literary work, it is lifetime of the author and plus 60 years. Now there is a specialty in this copyright. Now for other intellectual property, you have to apply and then you have to get the right. But in case of copyright, it is automatic. No need of getting copyright. It is automatically protected. But why we propose to have that copyright? Because once you are getting the copyright, your right is established. And in case of litigation, if your copyright is infringed, then you can have a legal remedy. You have to go for legal remedy, and in that case, you can establish yourself that you are the owner of the copyright. That's why one should get copyright registration. And for design semiconductor integrated circuit layout, it is IC design. It is for a period of 10 years. Now, these are the 6 different IPs which is governed by our office. And now, how you can file your IP application and where to file and how to file. Now, we are having both online as well as offline filing facilities. And it is generally encouraged to, for online application filing. And we are giving some fee reduction in case of online filing. And because of this current pandemic situation, there is no need to visit our office for filing IP applications. In case of patent, from filing to disposal of that patent application, everything is online. And for legal entities and for patent attorneys, it is mandatory to file online. And it is a lot of advantages to file in online application. And it is we are encouraging, especially in this situation and also in normal circumstances, that why you want people to unnecessary come to this office or any IP office for filing, just filing his application, where we are having online facility. And we are having offices in different locations. Now for patent, we are having 4 offices, and jurisdiction is defined. Now those who are residing in Eastern Zone and Northeast, their jurisdiction is Kolkata office, so they have to file application online. They can file, and their jurisdiction is Kolkata. And for other offices are having their own jurisdiction. In case of trademark, there are 4 offices, and there is another office that is in Ahmedabad. And for design, industrial design, it is one office that is in Kolkata. And application can be filed in 3 other offices, that is Delhi, Mumbai, and Chennai. And then that file is transferred to Kolkata for examination and for disposal of that design application. And for GI, it is in Chennai, GI office. And in case any hearing, actually in all cases, hearing is conducted before giving that GI right. And hearing takes place in respective jurisdiction. That means if any application is filed from Eastern Zone or Northeast, then the hearing will take place in Kolkata office. And in case any application filed in UP, then hearing will be conducted in Delhi office, like that. And for semiconductor, it is in Delhi, and for copyright, it is also in Delhi office. So, and in all cases, it can be filed online. So this is the, in nutshell, that is the structure of this our office. And for patent, actually, we are now we are having a lot things of around 900 officers in our office, and we are doing it very fast. Earlier, there was a ribbon of applicants that we are not, we have to wait a long time for getting our application examined and decision given in our applications. But now the scenario has changed a lot. So we are, in case of applications filed through PCT route, we are doing sending the examination report of applications filed in this year itself. And there are some other avenues in which one can get patent within a year. And for design also, within 6 months, one has to file the reply after once the examination report is issued. From the date of filing, within 1 month, we are issuing that report for examination. And then from 6 months from the date of filing, they have to file the reply. So in all cases, we are taking from action. And now suppose whether what is the territory for which Indian IP office is giving the IP right. It is since all IPs are territorial right. So the IP right which is given by Government of India, that is valid only within India. Now, if an application is patented in India, whether one can produce that particular item in other countries, like say our neighboring countries in Bangladesh or Sri Lanka, yes, they can, provided there is no patent in those countries. So, no way they can be prevented from manufacturing. In case an applicant is interested to get patent in other than India, he has to apply through PCT route to those PCT member countries, and then subsequently he has to select. Same is for design and design, and so that way one has to pick up a strategy where he is interested in doing business, and accordingly he has to chalk out his business plan. And I think before concluding, I would like to mention another very important point, that Government of India now encouraging the people to file more IP applications, and for that purpose there is a fund has been earmarked, and there is a facility that is for providing facilitated free of cost in filing IP in the field of patent, in the field of design and trademark. And this facility is provided to startup, all startups, and what they have to register in the DPIIT portal as a startup company, and they are getting a lot of other benefits. And end of the day, if his IP right is given, then he is going to enjoy that IP right, and Government of India in return is claiming nothing. And he will get professional assistance from the empaneled IP professionals. In our website, their names are listed. So they are going to get that assistance from them, and free of cost, and only the basic filing fee that has to be paid. And for getting the assistance from professionals, they are need not to pay anything from anything, and all the charges will be paid on behalf by Government of India. And in our website, you can a list is provided of different facilitators, and from that list, one startup company can choose that any facilitator as he decides. And what is the role of the facilitator? They assist in filing the application, and then providing assistance on different IPs of startups, and information on how it has to be protected and all these things that will be discussed. And they just continue to provide assistance till the disposal of the application related to patent, design, and trademark. And now, in case of patent, what they do, they do the drafting of complete specification, which needs to be accompanied with the patent application. And drafting of complete specification, and then that has been done by the facilitators. And then then the particular application from the startup is examined, and once the examination report is issued, then again the reply of that examination report is drafted by the facilitator. And after that, if this report is satisfactory, then application is granted. And otherwise, if it is still some requirements are pending, then hearing is offered. And on behalf of applicant, facilitators attend the hearing. So then after hearing, the patent application is disposed. And how the facilitators are rewarded? Facilitators are rewarded by receiving payment from patent office. In case of patent filing, they get initially at the time after filing, they get 10,000. And in case of amended stage, if it is filed and application is disposed in favor of the applicant, then another 10,000. And if in case of hearing, and if it is disposed after hearing, and then it is 15,000. And for design, it is initially 2,000. In case of trademark, initially it is 5,000, and subsequently at the time of disposal is 2,000, 2,000. And in case of if it is disposed after hearing, then it is 5,000 for trademark, and for patent it is sorry, for design it is 4,000. Now, what is the important point is that the statutory fee, that means the basic filing fees, has to be paid by the applicant itself. And who will get the ownership? Ownership is the startup is going to get the ownership. And the scheme doesn't in any way the startups or the facility to grant the now how this application will be dealt. It will be examined as per the action rules in for prevailing action rules of patent, design, as well as trademark. There is no privilege that since it's a startup application, it will be get some relaxation. No, it will be governed as per our acts and rules of patent, design, and trademark. And if it is found that it is okay, then it will be granted. And there is another feature for patent, that is expedited examination. Normally, what happens after once the application is filed, after 18 months, it is published. 8 months, it is published after 18 months, and but in case of patent, there is another provision. One can go for early publication by filing a request on Form 9. So in that case, it will be published on after almost within a month. It is published, and after that, it is if request is there, then it will come in the queue for examination. But in case of expedited examination, now earlier only the company who only startup company and those who have chosen India as a search authority were eligible for expedited examination. But now a lot of other entities also included for getting this expedited examination. That is small entity, and that means who are registered under MSME, and female applicant. At least one of the inventor is female, and then government department, institute, and undertaking, or government company, and application from foreign countries whose patent office has entered into a special agreement. So far, we are having on special agreement with Japan only, that is Patent Protection Highway (PPH). So up to a application of 100 applications, they can Japanese company with their priority can file in India. That will be taken out of turn examination. And similarly, Indian companies or Indian inventors, they can file the first 100 applications which is filed before Japan in Japan Patent Office. That will be taken up as a out of turn for expedited examination. That is the another benefit which has been introduced, and basically objective of the government is at present that our young generation should be more and more encouraged for creating their own IP, and it is not necessary that only it is for patent. Now for design, if people are doing business, say garment industry, leather industry, so many other industries, they can have their own design, and if this design is attractive, they can have good business out of his for his product. And and trademark is basically a brand value. That is also very important, because you see that in food chain now, Arsalan is a very famous name in the field of biryani. Now Arsalan biryani is very famous. Now suppose in say in a remote area, if a biryani shop is open in the name of Arsalan, then immediately it will have customer, because his brand is very well known. So that is the brand value. So if startup are going for his own company, they should have his trademark registration. And if he is having good established himself in future, he can give franchises to his allow other companies in other region of our country to use his brand name. And there was an example of litigation between that owner of Monjini's. He just gave the franchisee to one Bengali to do the business in Eastern Zone, and afterwards there was some problem among them, and ultimately the matter went to court, and then Monjini's were not allowed to do business for the next 3 years, and by this time that brand name was changed to Miyamore. Now after 3 years, Monjini is coming heavily in Kolkata. We will see lot of Monjini's tech shop is there. So that is the importance of brand name. So this is in a nutshell, and next speakers will elaborately discuss the other deeper aspects of IP, and I hope that you people will be benefited, and you will take your time in just thinking how further development in the field of IP can be carried out for the growth and prosperity of this country. With that, I would like to conclude, and I would like to thank you, all of you, to just listening to this program, and all the learning faculty members and principals and organizers for giving me opportunity to share our views regarding IP. Thank you very much.
Thank you so much, Mr. Bhattacharya, for your inaugural address. I sincerely apologize on behalf of the college, on behalf of my team, for this inadvertent error, which I am sure you understand is a typological error of getting the surname wrong on the flyer. But sir, if only you could kindly point it to us before, we would have definitely rectified it. Anyway, sir, thank you so much for sharing the technicalities of IPR, the structure of your office, and the method of application that you talked about, and the application fees, and that you shared with us. Thank you again and again, and especially for reminding us that our webinar on IPR will fetch us 5 marks in that. So thank you for your best wishes too. Yes. I shall now request, yes, sir. I shall now request Sri Tushar Kanti Roy, Head, Department of Zoology and member IQAC, to introduce Professor Low from Malaysia to us. I would like to share with all of you here that Professor Low was one of our esteemed resource persons in the International Faculty Development Program that was organized at the end of July this year. We are extremely proud to have ma'am with us again. So over to you, Tushar, for introducing ma'am to us.
Am I audible, Mitali? Hello.
Yes, you are, Tushar.
Thank you, Mitali. I am very privileged to introduce Ya Yun Lo, such a dynamic personality. She is a professor of psychology at the Faculty of Medicine, University of Malaya, Kuala Lumpur, Malaysia. Currently, Professor Lo is the Deputy Executive Director, Research and Internationalization at the Asia-Europe Institute, University of Malaya. She is actively engaged in teaching, research, service, and consultancy. Her research interest revolves around behavioral medicine, health promotion, sexual and reproductive health, HIV/AIDS, men's health, and aging. Currently, she is also involved in 3 international research projects on COVID-19. She is involved in the Erasmus multi-partner joint project on the research capacity building in higher education in Laos, PDR. She is also involved in a 6 Asian countries research project on the strengthening of surveillance system for NCDs, prevention and control and health promotion. Professor Lo has published 20 books and book chapters and about 250 publications in the peer-reviewed journals and conference proceedings. She is the managing editor of Asia Pacific Journal of Public Health and also the president of Asia Pacific Academic Consortium for Public Health. On behalf of IQAC as well as of our college, Minalini Datta Mahavidyapith, I'd like to thank you, ma'am, for providing us the opportunity from here from you. Over to you, ma'am.
Right. Thank you so much, Dr. Mitali and the chairperson, and also Dr. Suman for the kind invitation to present this lecture. Can you hear me?
Yes, ma'am. Perfectly.
Yeah. Okay. Now, I think I need help with regards to my sharing of my slides. Can someone help me out here? How do I share my slides here?
Yes. Shumon, are you there?
Yeah. Kindly, madam, kindly present now.
Okay,
your whole
yeah, I present now. So do I click your entire screen or just a window?
Yeah, you can both. You can share a particular window by using your PPT, and also you can. It is better to you can share the entire screen.
Okay,
at first you,
so here now I'm sharing.
You present the your entire screen, then go to the particular slides. Now it is presenting. Yeah, it is your entire screen. Now minimizing the your.
Okay, so can you see my slides?
No. Now you just minimize your browsers and open your slides.
Okay, open my slides. I'm sorry about that.
No, it's fine.
Okay, I present now. I click a window, right?
A window and then your presentation.
Right. So where do I get my slides?
Now, actually, it is not. Just minimize your browsers and open your slides. So you can see.
Okay. Can you see my slides?
Still, it will take some time, 1 to 2 minutes. Don't.
Can you see it?
No, still not now.
Not as of now, ma'am.
Okay.
So one thing you can do it that you may send me the. Is it possible to send me the slides?
Yes, I think I sent to you. So maybe you can get
you will continue your presentation. Then I will show you slides from here.
Oh, okay, okay. I'm so sorry about this.
No. You can send me the slides right now, so I'll present.
Ma'am, you just need to mail it to Shumon. He will show the slides on your behalf.
Right. I'm so sorry about this.
That is all right, ma'am. It's perfectly all right. I should request all other participants to kindly mute their
Kindly mute or kindly
Okay,
mute.
I sent to you now.
Okay. Yes, got it.
Got it?
Yeah. Let me 1 minute. Let me give some. It's opening in my browsers. Yeah, it's already open. I am presenting. Yeah, I think everyone is able to see the slides.
Yes, we can see the slides.
Okay, so you'll be controlling the slides, yeah, Dr. Suman?
Yes. Already I presenting. You can.
Right,
Can you
right.
see, ma'am?
Yes. Thank you.
Okay.
Right. So,
you can continue. I am changing the slide. No problem.
yes. Yeah, I will carry on now. Okay, so a very good evening. Here in Malaysia, it's already 7 p.m. here, and good afternoon to all of you over there. Okay, now the topic that I'm presenting is on publication ethics. Yeah, and so next, please. Next slide, please.
Yes, already it will take
Okay,
little
it will
bit
take
time.
time. All right. Okay. So this is what I will focus in my, 20 minutes of lecture. So these are the various concepts I will go through on plagiarism. What is authorship, copyright, duplicate publication, simultaneous submission, fraud and forgery, acknowledgement, wrong credentials, falsification of data, and citation bias. So I think as a student or as an academic, young academic or a researcher, I think it's important to educate, our students as far as ethics is concerned, not just regarding the research itself, but also towards the end where we need to, write up and submit, to a journal for publication. So I think all researchers need to know at least something about publication ethics. Next, please. Right, so what I'll walk through with you, two main objectives for this lecture is to understand the importance of publication ethics and of course to understand ethical issues in academic publishing. So publishing here can mean anything, not just a journal publication, but also writing of your thesis, writing of your research report and what have you. Next. Okay, now publication is the endpoint of any research. So it's important that when you carry out research, there are ethics involved in the whole research process. And at the end of the day, you're writing out, your findings. And again, here, if you do a lousy research, you get a lousy publication. So very important, you have to design your research in such a way, that at the end of the day, you produce a very high impact publication. And of course, you do need to adhere to research ethics, and at the end, publication ethics. And this is why I'm here just talking about publication ethics, and that's the end point of any research that you are doing. Next. Okay, now, what is scientific misconduct or publication misconduct? Now, when you talk about scientific misconduct, it's more broader. Yeah, it's much, much broader. Yeah, it consists of your research misconduct and what have you. Here, I focus on publication misconduct, and this is the US Office of Research Integrity that defines scientific misconduct. Now, it's a fabrication, falsification, or plagiarism in your proposal, in performing or reviewing research, or in reporting your research results. So it's not just towards the end, but at the end, prior to that, when students, you're presenting your research proposal, very important, you cannot plagiarize a proposal from somewhere else, or you cannot falsify the data or the figures they are putting in your write-up. Next. So this is the scientific misconduct. So this is the fabrication, this is falsification, and this is plagiarism. So very important, it's a big no-no to all these three aspects of scientific misconduct. And I'll go through each and every one of it in more detail. Next, please. Now, fraud and forgery, meaning, you falsify your data, you cook up your data. There is no such data, but you went to cook up your data, right? Or fraudulent results. Now, this is a very serious misconduct. And not only that, because research involves funding, and you may obtain funding, from your sponsor. So really, you are cheating taxpayers' money. And again, you are putting out very misleading information if you cook up your data, and it misrepresents your, it can also mean a misrepresentation of your academic credentials. Now, academic credentials here, meaning sometimes, you may be, let's say, for instance, a master's student or a PhD student, and even before you complete your degree and you're publishing a paper, and after your name you put your degree there, your MSc or your PhD or what have you. And of course, all this is a big damage to the image of scientists. Next. Okay, falsification of data, yeah, selective reporting, of your findings, and omission of conflicting data. Now, sometimes this is where young researchers or even young academics or even students, yeah. So because sometimes they panic when they find very conflicting results, and they deliberately throw out, those kind of findings in their report. Yeah, so this is a willful suppression or the distortion of data. So I think as authors, we need to be very careful in terms of our calculation. Make sure, when you're producing a table, make sure it exactly adds up to 100% and not, 99.1 or, 101%. In terms of your data presentation as well, and you do need to show proof, of how you actually derived those data or the figures or any calculation for that matter. And authors should present their results honestly and without fabrication, falsification, or misappropriate data manipulation. Now, very important here, perhaps we are in the social science, it's not so much as happened in the sciences, where, sometimes images that you have, you can manipulate your image, yeah? Next, please. Okay, falsification of data, very important in describing your methods, your research design, it's very important, your methods and material section, yeah, in any publication, for instance. So this is where we gauge the validity and the reliability of the methods that you actually use. Yeah, so once we read your method thoroughly and it's valid, you need those kind of things to present your findings clearly. Yeah. And so if you do have any international guidelines in terms of your write-up, you do need to follow those international guidelines. Report of research should be complete, So you really leave it up, to your examiners, to the reader, to gauge, whether they believe in your findings or not. But your job as an author to be very convincing, to give evidence, the right proof, as to how you actually derive, the findings that you have found. Next, please. Okay, next I'm moving on to authorship. Now, this is again an issue, that is universal. Not, I wouldn't say it just happened in, it only happens in Malaysia or in India or in Bangladesh, anywhere else, even in the US, Australia, or in Europe. So these are some of the common unethical practices. Unjustified authorship, very important. Political authors, ghost author, or a deliberate exclusion of valid collaborators. So I will go through, what actually defines, an author to be. Next, please. Okay. Now this is, how we, characterize an author. Who actually constitute an author? How do they deserve to be an author? Yeah. So number one is, all the substantial contribution towards your conceptualization of your research idea, very important. Your study design, you have to contribute towards your data collection, your analysis, and the interpretation of your data as well. And it's capital N, A-N-D. Drafting of your article or critically revising for important intellectual content, and A&D, final approval of the version to be submitted and published. Yeah. So as an author, you must give approval for the submission. If you don't agree to anything that is stated in the paper, it is best for you not to submit the paper or withdraw yourself as an author. And most important of all, as an author, you have to be accountable for all aspects of your work, in ensuring that questions related to the accuracy or integrity of any part of the work, come to a consensus and to be resolved. Very important. Next. So moving on, it's how we define the principal author. Now, principal author is the main author here. Okay, in any paper you see, the main author, is normally the first author. We call that the principal author. So normally the principal author, she or he would have the major input in the study, all right? So that's key guidance, and also in preparation of the manuscript. So normally the first author or the principal author actually drafted the paper, yeah? And the first author is normally recognized by all the other co-authors or collaborators in that particular research or study. Next.
Can you see, ma'am?
Next, please.
Yeah, I have put it. Authorship.
Right. Okay. Authorship, institutional and journal authors. Now, this is something that we would like to discourage. Very important. Yeah. Who are the guest authors? Now, guest authors do not meet accepted authorship criteria. Just now, the previous slides, you have seen all the 4 criteria for being an author. So these guest authors are those who do not meet any of the accepted criteria, but are listed because of seniority, because of reputation, or their supposed influence. All right. So sometimes you will get, like us here, you will get things like, you will hear things like, okay, it's because I'm the dean of the faculty, or because I'm the head of department, so any paper that gets out from my department must have my name on the paper. Now, this is clearly, an abuse of power. So again, that, is a guest author. Now, a gift author, those who do not meet accepted authorship criteria, but are listed as a personal favor or in return for a payment. Yeah. So you may have a friend who is in a different department, and you're here in this department. So when you write, you put his or her name in your paper. And when your friend in the other department writes his or her paper, he or she puts your name in their paper. Okay, the other one is ghost author. Yeah, ghost author, those who have met authorship criteria but are not listed as an author. Yeah. Now, ghost author, it's very, very common, particularly in the field of medicine. Yeah. And in some huge pharmaceutical industry as well, they would normally hire a ghost author to write up, say, for instance, a clinical trial. So they will pay people to write their paper, but the author themselves, their name are not, on the paper itself. So that's a ghost author. So these are all the big no-no as far as authorship is concerned. Next, please. So these are some of the authorship issues. I'm sure, some of you could actually relate to this. For instance, a deserving junior researcher, was omitted from the authorship. Why? Because he's junior, and a sponsoring company insisted on the inclusion of opinion leader who has made virtually no contribution to the study, or the writer of a review article or any article found her name replaced with that of her boss because she was on maternity leave when the final version was submitted. So forth and so on. There are lots and lots of authorship issues, yeah? And authorship issues, are actually a universal problem. Right, next, please. So really good authorship practice require an understanding, very important. And I would suggest that even before the completion of your research, you sit down together. If you have collaborators working on the same project or the study, come together and define as to who should be an author in a specific paper that you're writing. So the understanding, it's very important among all the collaborators. And of course, acceptance is very important. If you do not accept anything that's written in the paper, then I think it's best for you not to put your name on the paper. Should anything happen, you are equally responsible because your name is on the paper. And of course, all of you have to agree, that a particular paper that you have written, is to be submitted for publication. So really, this is what authorship means, yeah? It's a responsibility. You have to bear the brunt, should anything happen, to the paper. Right, next, please. Right, next to authorship, I purposely talk about acknowledgement. So those who don't deserve to be an author, but you think they have helped you in your study, you do need to thank them, in print. But very important, when you thank somebody in the acknowledgement in your paper or in your thesis, it's best for you to ask permission because people want to know that, they have been acknowledged. Yeah. And this is an appreciation to your mentors, to the technical assistants, and whosoever that have helped you indirectly in the paper. And you have research funding as well. You do need to acknowledge them. Where do you get the funding from? From a Ministry of Science and Technology, from Ministry of Health, Ministry of Education, from World International Body, and what have you. And if you do have a conflict of interest, then you do need to declare it. Say, like, for instance, you're writing a paper and, you partly own the company, or you're a staff, in a company that manufactured, let's say, a drug, then you have to declare your conflict of interest. All right, moving on, please. Now, we are moving on to plagiarism here. Yeah. And so I think this is extremely common among our young junior academics or young researchers or even students. All right. And so this is actually, using other people's published or unpublished words or ideas without their permission. All right. Or presenting them as new or as yours. Yeah. And also we have this thing, what we call the self-plagiarism. So this is basically, you plagiarize yourself, you have your work that is published, and then you copy from your own work. Yeah, so that is what we call self-plagiarism. Next, please. Okay, now plagiarism can be intentional and non-intentional. So intentional, it's like verbatim copying of, the whole paragraph, or the whole page, and this is considered theft of intellectual property. because the intellectual property doesn't belong to you, it belongs to somebody else. So give credit where it's due, very important, yeah. And common examples easily found, students who tend to do this, young researchers and even reviewers, because sometimes we can act as reviewers. Articles are sent to us for review, and then we went and copy their work, all right? So this is downright plagiarism. Next, please. Right. So plagiarism, authors should represent the work of others accurately in citation and quotation. So if you're copying something that doesn't belong to you, so you do need to give a citation or a reference to it, very important, because the work does not belong to you, it belongs to somebody else, yeah? And authors should not copy references from other publications if you have not, read the cited work. So the onus is on the researcher, on the author themselves. Whatever you cite, make sure you know what you're citing, yeah? And authors should alert the editor promptly if they discover an error in any submitted, accepted, or published work. That's very important. Next. Right. Okay, now duplicate submission, publication. Again, this is a big no-no, yeah. Resubmission of published work, your work, it's already out, and then you paraphrase it, change it a bit, and then publish it somewhere else, yeah. But this does not apply to oral and poster presentation at conferences. Now, when you attend conference, you do an oral presentation, you do a poster presentation, you convert that, we will encourage you to convert that into a proper paper for publication, all right? So that does not constitute duplicate submission or publication. And this does not apply to secondary publication in different languages with permission from editors. Sometimes you may have a publication that's published in English, but you want to translate it, into Tamil or Hindi or Chinese or whatever language. You do need to ask permission from the publisher or from the editor that you wish to translate it. All right. Next, please. Okay, simultaneous submission is a big no-no. This is also very common among our students. Yeah, where you submit a publication to different journal at one time. Yeah, so this is a big no. So normally, we advise students to just submit to one journal first, then until you receive the rejection letter and you submit it off to another journal, all right? So you wait, you don't submit to 4 or 5 journals at one go, yeah? So, what happens is this, constitute a waste of time of editors and reviewers. And of course, it casts suspicion of possible duplicate publication. Next, please. Okay, now copyright, I think the previous speaker has talked a lot on copyright issues here. Now, normally copyright belongs to the publisher, yeah, unless in an open access journal. In most open access journal or almost all the open access journal, the author owns the copyright, okay? But if it's a traditional, which is not an open access journal, then that article belongs to, the publisher, all right? So this is a clear violation of copyright. It's very common among students, and students need to be educated, as far as ethical issues are concerned. Reproduction of text and illustrations. You're copying something, a table or figure from a book. Now, you must get permission from a publisher of the book. Yeah. If not, the publisher can actually sue you for copying their things. Okay. You always seek permission from a publisher, especially if you're a, lecturer, or even like now, we do need to copy a table or a figure or a map from somewhere. We do need to get permission from a publisher. And normally the publisher would grant you the permission is because you have to write in such a way that, this is your final year, you have to submit your thesis, and therefore you need this, table or figure to be put in your thesis. And normally they will grant you that permission. And it's very important for you to keep that copy, of that permission that you have gotten from the publisher. Next, please. Okay, misappropriation of ideas of others. These are ideas of others, yeah. And then very important, give credit where it's due. Now, this normally happens sometimes, like for instance, you send your research proposal, for funding and whatnot, and suddenly, you fail to get the funding, but you realize that some of your colleagues in another university or elsewhere, have the same idea, exactly the same idea like yours. Yeah, so this is improper use of ideas from it belongs to other people, but you steal their ideas. This can be either wholesale or partial. So all this constitute a misconduct. Next, please. Okay, citation bias or misrepresentation. This is bias towards citing work of Western world rather than developing countries. Now, sometimes we think, any work that comes out from the Western world is more superior than coming out from developing countries or undeveloped countries. So we purposely, cite their work, rather than, our own work. Yeah, so we think that, their research work, their publication is of higher quality as compared to other parts of the world. Ignoring important and valid work as well. This is again very important, particularly those of you who are students here in this webinar, master's or PhD student. If let's say you do know your examiners or whatnot, it's good to read up on their work and cite their work, very important. So you do need to give the latest reference, yeah, very important, citation of the field you're researching into. Misleading interpretation of published work. So sometimes intentionally you leave it out, yeah, or sometimes you really don't know, but ignorance really is not, a place. So preferential setting of reference to suit research finding. So let's say, for instance, your statistical analysis, they're all positive, they're all significant. So you purposely choose references that have also significant findings, that also have positive findings, yeah, to back your own findings up. So this is what we call preferential citing of references, yeah. Or some people would purposely choose those references or studies that are very impactful, yeah. So even though your study may not be significant or positive, so a negative finding or non-significant is also an important finding to tell the rest of the world. Next, please. Now, this is what happens for unethical publication. Yeah, so, speaking as an editor myself, if I find all these unethical publications, what happens is sometimes, the editor can, retract the paper or withdraw the paper, very important. So you have to watch out, there is a website called Retract and Watch, and those are the articles that have been retracted. And also, we can also make an editorial announcement in our journal that this article, has been retracted. And sometimes the editors inform authors institution as well. So like, for instance, I run a journal, the Asia Pacific Journal of Public Health. So if I do find any scientific misconduct, and sometimes I will write the letter, to the head of department, to the dean, and sometimes to the VC as well. So it depends on the severity, of the scientific misconduct, done, by the authors, yeah. So if you're a student and you're writing your thesis and you're caught for all this unethical publication, you can fail immediately, all right? And as academic staff, sometimes, we can be suspended, or we can be sacked from our university, yeah? And of course, at the end of the day, you will bring shame to the whole, university, to your own research group, and to yourself as well. Next, please. Right. Right, so this is just an example of what retractions papers are in 2020, yeah. Just to show you, these are some of the papers written and they have been actually retracted, okay. Next, please. So this is how a retraction paper will look like, yeah, very important. Please be aware that, it's not, we cannot possibly withdraw the article from the website, yeah? So the article will be there for the rest of your life. If the article is retracted, and this is what it's going to be, the word there will be retracted. So that means your children will see it, your grandchildren will see it, your great-grandchildren will see it, yeah? Because there's no way we can, download the article from the website. So be very, very careful, be very vigilant, please do not commit, this kind of unethical behavior, and this will be the consequences, yeah? Next, please, my last slide. So at the end of the day, what we have here is you have to ensure that your published work adhere to the highest publishing ethical standards, yeah? And should there be any scientific misconduct, it will be reported to the institution. I think in any institution, you will have a disciplinary committee that looks into all these cases, yeah? And you will face repercussions and will lead to embarrassment, punishment, suspension, or termination of an academic service, or even, they will kick you out from your faculty, yeah? And the reputation of the author and institution will be damaged, and you must always hold the highest regard for publication ethics. Next, please. That's okay. Right, so those are the references, and then finally, just sharing with you a book on publication. Right, with that, thank you so much for your attention. Thank you. Thank you, Dr. Suman.
Yeah. Just I stop sharing.
Thank you so very much, Professor Law, for throwing light on publication ethics. You have discussed research and publication misconduct, and you talked about falsification, fabrication, and plagiarism. And especially, like with higher education academics in India, which is constantly asserting more and more on research and publication. I think your discussion on authorship issues is going to be extremely beneficial for all the academicians present here today. And I must again thank you from the bottom of my heart for responding to our call so spontaneously. And we really hope that this, Mrinalini Datta Mahavidyapith, the MDM family, will have a long-lasting relationship with you, ma'am. Thank you so much.
Thank you.
Thank you, ma'am. I shall now request Srimati Nandini Chakraborty, who is the head Department of Journalism and Mass Communication. She's also our esteemed member governing body and also member IQAC, to kindly introduce Professor Pratap K. Das to us. Over to you, Nandini.
Thank you, Mitali, and thank you, Principal Sir, respected Principal Sir. Am I audible?
Yes, you are. You are.
Oh, thank you, thank you. Thank you once again, Mitali, and thank you, our respected Principal Sir. Good afternoon, everybody. Welcome, Dr. Pratap K. Das. Professor Das is a retired senior scientist of Indian Institute of Chemical Biology. And at present, he is an honorary guest faculty at Ramakrishna Mission Vidya Mandir, Belur Math, Department of Microbiology and Zoology. He did his MSc in Biochemistry from University of Calcutta in 1974 and PhD from the same university in the year of 1982. His postdoctoral fellowship from State University, New York, USA. His area of interest are like teaching and research on chemistry, biology interface, innovative system management, motivation of young minds, effective communication skill, discovery, development, and commercialization of herbal drugs, IPR management and patent, research planning, and proposal writing. Dr. Das supervised several research scholars. Dr. Das has 25 research publications, 4 patents, and 3 chapters in books. Dr. Das is a referee of several journals like Indian Journal of Biochemistry, Natural Product Radiance, Journal of Scientific and Industrial Research, African Journal of Pharmacy and Pharmacology. Dr. Das is involved in many other activities like editor-in-chief of a book on IRCB in retrospective, principal coordinator of a CSIR documentary film on herbal therapeutics involving 10 CSIR laboratories, science popularization work among school students, popular science lecture in schools, colleges, and social platforms. The topic of his radio talk in Akashvani was popular science topics. He got INSA Royal Society UK Fellowship. Thank you. With this short introduction, I am requesting respected Sir, Professor Dr. Das, to deliver his lecture. Thank you, sir. Over to you.
Dr. Das, can you able to show your slides?
Has he mistakenly left the platform, Shumon? I can't see him suddenly.
I think so.
Do you have a phone number of Dr.
Yes, Debashish, could you kindly call him up?
Yes, I am trying.
Yes,
I am
yes.
trying to, yes.
Yes.
I think he is mistakenly. So in the meanwhile, is it possible to take some questions? So Mitalidi.
Yes, yes. In fact, I was about to request all the participants to kindly type their questions on the chat box, which could be taken at the end of the session. But
Yes.
if we have any question already, we might go into it. Or should we wait for another 2-3 minutes for Professor Das to return?
Yes,
to
yes.
the platform?
I think we should wait for.
Yes, yes. Dear participants, if you have any questions, kindly type it on the chat box. We will take the questions at the end of the session, and I shall request Dr. Shumon Chakraborty to read out the questions at the end. So I think we have a couple of questions already, and maybe a few will also come in.
Yes, yes. So one question Professor Low put here to Sanjay Bhattacharya. What about copyright law in this digital age? What about copyright law in this digital age? So this question put by Professor Low to Sri Sanjay Bhattacharya. So
Mr. Bhattacharya is here on this platform, or has he left?
yeah, he's in. He's in.
He's there. He's there. Okay.
But mute and also stop his videos. I don't know whether he is in here or not.
Okay.
Anyway, when he will come, he'll answer these questions.
Yes.
And beside this, as Dr. Suchishmita Sen Chaudhary put one question to yes, Professor.
Mr. Bhattacharya is there.
Mr. Bhattacharya, Professor Low put one question regarding your presentation. Then what about the copyright law in this digital age?
Actually, regarding any IP Act, in our website, we have provided frequently asked questions. Our website is ipindia.nsc.in. Now, what is the provisions of our act, different IP Acts? All are available in our website. So, if anyone is having any queries, they can just see our website. And if not satisfied, then we are having our own mail ID, that is Kolkata_patent @nic.in. He can just drop a mail. Then we are going to answer.
Okay, thank you.
Yes, I think Professor Low got this point. So beside this, Mr. Bhattacharya,
Yes.
I have a specific question regarding the IPR, intellectual property rights, whether you are considering the cultural issues of a particular group or anything in the IPR in Indian law. I don't know whether is there any cultural significance, cultural issues are related to the IPR. As because my background is anthropology, I am doing little bit of work among the different human groups. Yes, Professor Das already joined, and hopefully we'll discuss it.
Suman,
Yes, yes.
can you present the PPT of Professor Das?
Yes, yes, definitely.
Yes.
Already I have shared it. So Professor Das, I am presenting. Kindly unmute your mic. kindly unmute your mic. I am presenting your slides.
Oh,
No problem. Okay. Thank you. Thank you. I am presenting.
Kindly show the first slide.
We can have
Yes,
the
I am
presentation at the end of this Professor Das's lecture then.
Yes, yes.
Fine.
Yes, you can start.
Thank you, Madam Chakraborty, for your nice and kind introduction. I also wish to thank Dr. Apurva Banerjee, Principal, and Dr. Mitali Ganguly, IQAC Coordinator. Wonderful initiatives. In fact, this is something which is warranted in this new era of knowledge industry. The topic on which, as you can see here, on which I shall be emphasizing is on patent perspectives in R&D. So its necessity in New India, its advantages for young investigators. I believe this seminar would help sensitize young minds, faculties, researchers of your college and other academic institutions around your college to look into the prospect of protecting their potentially useful research through patent and making a focused invention which could be potentially useful in the end, and finally converting an attempt to convert your knowledge into commercial product, meaning taking Saraswati to Lakshmi art kind of things. Having said that, I would just briefly say, as already Dr. Chakraborty during introduction told that I'm a retired scientist. I happen to be a national laboratory in CSR system called Indian Institute of Chemical Biology. At some point of time during my research career, I was encouraged by the CSIR to protect our research efforts and achievements in the form of IPR, as you know, intellectual property rights. Hence, I have some experience in what we call as patenting and research outcome. As patenting of the research outcome. This in brief I intend to share with you. So today I will basically emphasize, next slide please, on three aspects. Next slide please, Dr. Chakraborty. These three aspects I would like to emphasize.
Already I put it.
Basically recalling what a patent exactly means, what is a patent, why to go for a patent, and when to apply for a patent, where to apply for a patent, and how to draft the patent, etc. Little bit of my experience I will share from the inventor's perspective as far as I can. And in the process, some of the hurdles that I faced, some of the challenges that I had to overcome, and some of the accomplishments that I got. So kind of agony and ecstasy in my research field that I would like to share a bit with young minds, young researchers, young faculty members. My domain, as I told you all, as she has already expressed, that it's around basically drug discovery from natural products. And the disease area where I specialize is basically what is called gastric ulcer, nothing else. So next slide, please. Intellectual property, as we all know, is a creation of mind. Property, we all know, already discussed by Dr. Sanjay Bhattacharya, that it could be movable, it could be immovable also, property in general. A property can also be tangible and intangible also. But this intellectual property is basically a movable property, and it is also an intangible property, somewhat intangible to start with. At the starting point, it would look somewhat intangible. I would not go into this details of different kinds of patents, like patents, trademarks. Dr. Sanjay Bhattacharya has elaborated all these points. So I go to the next slide. Basically, coming to next slide, please. Basically, it's an intellectual property. So it's a creation of mind, because we know that there are issues of patents which comes from, it is just not invention, but it's something more than invention. We sometimes tend to call it as innovations. So basically, we have to remember that the issue of generation of a patent and valuation of a patent and also protection of the patent, all these things are critically important because of a few reasons that we felt I must share with you. First point is, we see and foresee increasing dominance of knowledge economy over the old style bricks and mortars economy, and thus the generation and protection of new knowledge is somewhat warranted. Second, there is an exponential growth of knowledge in the field of science. We all know about that, particularly in life science, in communication science. Maybe it is accruing to the discoveries of big stuffs like, say, Human Genome Project or Internet Protocol, or say biomedical engineering related devices, creating issues like creating diagnostic tools like, say, positron emission tomography, brain computer interfaces, MRI imagings, diagnostics for early detections of cancer. So many things are coming nowadays, and here comes the need for new forms of IP protections. Third, we have to address and understand and appreciate that the emerging complexities of the IP process also in general, we have to understand and appreciate theirs. Like, for example, there are traditional knowledge. Like in case of India, traditional knowledge like use of neem, haldi, these are traditional knowledge. These are already patented, meaning it is already known in India, so we cannot make fresh patents for such issues. There are community knowledges, like local people around a community have developed some knowledge, like as was told, Ikkat Shari or Mysore silk, some kind of community knowledge. So geographical indications is a property of that natural regions like Darjeeling tea, Basmati rice. It cannot be created anywhere, produced anywhere else in the world. So we must remember these things. So thus we need to be aware of such developments, being generation next intellectual citizens of India. Just not awareness, but the skill and the competence in leveraging its influence. We need to leverage its influence so that we can take advantage of that. So we need to basically develop some skill, some view around this patent art. Discovery, as you all know, is not invention. Invention is not just what I would like to call as innovations. Take for example, say elucidation of double helical structure of DNA. It's a discovery. But exploration and exploitation of such knowledge to produce a new artificial DNA, maybe for some purposes, is inventions. That is patentable. So for invention to become an innovation, we need to add a few more attributes to our research work, like whether or not it is desirable to users, whether or not it is possible through technological practice, and finally whether or not it will be viable in the marketplace. So if it satisfies such criteria, we can sense that we have turned our inventions to a level of innovations that becomes a good candidate for patenting. That becomes a sure shot candidate for patenting. Therefore, we can think of, basically, if we can think of whatever we try to do is there are two arms, whether or not it is doable and whether or not it is desirable. If we can make something which is quite doable and I did it, but it is not desirable in the society, in the marketplace, it's not good for patenting. It is something I thought of is highly desirable in the society, in the marketplace, but I'm failing to make it. I'm failing to do it. I'm failing to prepare it, the product. So it is not still a candidate for patent. That's what I want to say. So thus, a patent should fulfill a basic inclination for covering the aspects of what is called novelty. Novelty means it's something new, and creation means just not novelty, but something new and valuable. Something new and valuable. And invention, on the other hand, would be, I would call it something new having potential value through utility. Something you can think of having value, but not utility value, of no utility value, of no utility value. And innovation, finally, is something new and becoming uniquely useful. By that I mean you are framing the boundary conditions for your innovation. It is not universal. So under such conditions, such product would be useful for such purposes. That boundary condition setting is innovation. That's what I want to mean. Coming to the point of patent, can I have the next slide, please? Yes, a patent is basically a grant, as you all know, for an invention by the government to the inventor in exchange for full disclosure of the invention, so that it restricts others to exploit this known invention for commercial purposes. And patent is valid for a limited period of time. In case of patent, it is maximum 20 years. And patent is country specific, geographically country specific. So a patent, if I apply for a patent, I have to apply for Indian patent or US patent or both, whatever I want. So I have to apply separately for such patents. Now, an important point is what is patentable. This is vital. Whenever you think of taking your invention to the patent route, you should first check out amongst yourselves whether or not your invention is fulfilling such criteria. A new product, or it could be a new process, it is patentable if it can fulfill the following three criteria. One is novelty, meaning it has not been anticipated earlier by any inventor or anyone. So it has to be novel. Second is it must involve quite a number of inventive steps. Just not obvious things can be patented. So it should be something which was not obvious. So it involves a lot of inventive steps to reach to that final stage, so that it looks visible as a product or a process which is very useful and even commercially useful. So third important criteria is patent should be industrial, must have industrial applications. So utility value must be there. So to be able to go for a patent, I must check beforehand at some point of our investigations, research outcome, that these three criteria, all three criteria must be fulfilled, not one or two criteria. All three criteria must be fulfilled. Then only I should go for seeking a patent. On the contrary, if I just mention a few examples of what is not patentable, we can say a few items like any natural law is not patentable. Anything like laws of morality cannot be patented. You have developed some laws of new morality, so that cannot be patented. Discovery of scientific principles cannot. Even a product, if it is war related or harming people cannot be patented. For example, AK-47 type of rifles you have designed and made a material which is, you are thinking that it is useful for killing a person. So, but that cannot be patented unless it is useful for society in general. Like atom bomb, any advancement of atom bomb cannot be patented. Or any pathogenic organism artificially made, a pathogenic organism hugely virulent, any microbe or any virus cannot be patented for biological warfare. Someone thought of making a viral things which is hugely pathogenic and want to take patent for that, that cannot be patented. So coming to the point, one important point is why to go for patenting is essentially three important criteria for inventor's perspective: establish monopoly right of my invention, of my intellectual achievements. I must establish monopoly, because if we just disclose what I have invented, then onwards it will be very easy to copy it. So unless I protect it in patent, it would be very easy to copy by any manufacturer or any person who are going for fresh patent by the inventor, and he will submit it to government of India or government of USA for patent ownerships. So we have to be cautious about that. Patent must be secure first. Summarizing what I said, can I have next slide, please? Next slide, please. A patent is a document describing the content of the invention for which the inventor gets a monopoly right from the government in the form of a granted patent for his or her intellectual achievements. This in the below the diagram, you can see an example of the patent document, wherein you can see this is an example. Just patent number will be there, a priority date will be there, and the title and all the contents will be there. I'll be telling about that. Next slide, please. I will talk a little bit around why to go for patent to young minds. You have to understand and appreciate few things. First is the importance and applications and benefits around going for a patent, around having a patent must be understood. Remember, your invention is developed. One line of thinking is that your invention is developed with investment and ingenuity from your institute, from your college. Funds are coming from your college. Funds are coming from West Bengal government. Funds are coming from India government for doing research. So it deserves to be protected. You have a moral responsibility. If it is useful, if it is looking like useful, you need to go for protecting these intellectual achievements. In the process, supposing, next point is, supposing you have the patent, what would you do? You can sell it outright to a manufacturer, because you have thought that I will not go for making a company, I will not go for manufacturing the medicines, I will not go for selling the medicines, looking for personnel, for marketing the medicine, etc. I will not go for, this is not my staple food, this is not my job. So in that case, I can license it out for a fees. License out for a fees. I can outright sell the patent for a huge sum of money. I can license out for a limited period of time, or with some conditionalities, for quite handsome money that I get, which I can redeploy for making more research, more invention, and thereby making more patents, so that it becomes a win-win situation for me as an investigator. In the process, it is also becoming a win-win situation for the institute, your college, your government, your society becomes the winner. Not just you, everyone will win. And the consumer who will use this product, separate anything, will be definitely benefited from the health perspective angles, or anything. Say newer things are coming, a competition is there, so material would become better, would become cheaper, in the sense that we all have seen the age of computer, laptop, camera, cell phones, more features are coming with lesser amount of money because of these competitions. And finally, the last point is patenting help avoid duplications. Just not it promotes R&D activity amongst all other investigators. It helps duplications. Once you consolidate your invention, no one will claim around that thing. So thus, I can summarize, patent system encourages inventors as well as inventions. Patent system encourages utilization of the knowledge, and this helps contribute to promote the technological inventions so that the transfer and dissemination of such technology can take place in a form so that society in general, government, country, government gets all are benefited. So it is a issue of win-win situations. Next slide. As I was telling that there are several patent offices in different countries, like Indian Patent Office, IPO. I wrote here the websites of different patent offices, US Patent and Trademark Offices, USPTO. We used to visit these sites. European Patent Office for the whole European Union, besides having specific patents for UK, Japan, France, I have applied there also. Also, I have applied for European patent, got it. And there are small countries like African countries, ARIPO countries, African Region Intellectual Property Organization. There are combined country-specific patent offices. East Eurasia Patent Office. China has their own, Japan has their own, Australia has their own patent office. These are the trademark designs and these websites I wrote it. One point I must add here, Dr. Sonia Bhattacharya also told it, a term called PCT. Supposing you have discovered or invented or worked out a molecule from a plant, somehow becoming or looking like extremely useful in treating cancer. Say, for example, 2-3 different types of cancers by the same molecule. You have isolated this molecule, which was not known earlier. So definitely you went for a patent, and definitely you are thinking of submitting patent to different countries, not in India, so that you can get markets of different countries. Just not patenting, but patenting in a country allows you to market your product. You can just license it out to a company of that country. You get the royalty, huge amount, which you can in turn use for further inventions. So there could be a term called international patent, but that term is not the right term. But there is an organization, social kind of organization, like WHO type of organization. We call it World Intellectual Property Organizations, WIPO, World Intellectual Property Organization. It's an international organization situated in Switzerland, wherein any person for their invention can submit, or rather should first submit, a one-page summary of his or her invention to there, to basically to seek a priority date of my invention. So it is in the website, everyone in the art can see it. So you have declared it officially, locked in the system of WIPO, and then you can use your knowledge to draft the patent, submit to India, submit to USA, submit to EU, submit to Japan as you feel appropriate. That requires a lot of time, energy, and money. Expertise also required. But best thing we learned about it, whenever you feel that it is worth patenting, quickly go for a one-page summary of your invention to WIPO. It is an international organization. It encourages patenting to any international inventions. So this is called Patent Cooperation Treaty. So we submit a PCT submission. We call it PCT submission. This is under conditions of WTO among the member countries, World Trade Organizations, for TRIPS-related GATT and TRIPS-related activities. GATT, you know, General Agreement of Trades and Tariffs. And TRIPS is our essential element, which is called trade-related intellectual practice. In terms of trade, there are intellectual points also. So there are trade-related intellectual practices also. So we need to submit a patent. Next slide. Please. Next slide, please. I will not get details into these things. What I would say, supposing I would end up talking along the line of patent drafting, last point. But before that, we must understand a patent involves many branches of knowledge. Just not science and technology and your invention of sound biology or drug discovery, whatever you think is not enough. But that is essential. That is the first start point. That is the last end point also. But in between, you need to take help of patent attorney little bit. You need to understand little bit about the commercialization of this product, so that you can appreciate what exactly to write. So patent involves many branches of knowledge. Drafting a patent document requires lot of skills. Next slide, please. So from inventor's perspective, on the right side of screen, you must ask yourself this type of yes/no question. You have created something, looks like it is new, looks like it would be useful. If not, don't go for patent. If yes, first thing is keep it secret, go for PCT submission, consolidate your patent right, and then also if you want to, you go for publications. Remember one point, if you publish anything, it cannot be patented. If you patent it, it can be published. No problem. For that, you need at least a PCT submission to WIPO. That is the tricks that we learned throughout our life. The last 10 years of my research career, I have learned all these tricks. So whenever you feel essential messages, young investigators, young minds, whenever you feel that my invention looks like useful and fulfilling all three criteria of invention, I will go for patent. I decide to go for patent. I quickly submit a PCT application. Then I complete full drafting of the patent, which is time-consuming process, requires some skill, but in any way, you are the right person that I will argue first. Supposing you are to write patent. Next slide, please. So my last part of my talk is drafting a patent. So now you know that your invention is just not novel. It consists of a lot of inventive steps also, and the outcome, be it a product or a process, is extremely useful and has industrial applications. So you start drafting a patent. To the national phase submission, meaning submitting to Government of India, Patent Office, submitting to USPTO, wherever you try, you first submit a complete draft, which we term as specification. It could be initially it could be a provisional specification, and later on it must be supported by a complete specification. There are major few elements in the patent document. It's about 10-20 pages document like research papers. Nothing to worry about it. It must contain a title of the patent. It must write 2-3 sentences about what field it is covering. So field of intention, and then you have to write 2-3 sentences around use of this patent summarily or objective of these patents. And then you write a full paragraph about 500 to 1000 words, supposing what are the priority art elements, like literature search, not just in PubMed, but in patent search. You have patent search facilities in all patent countries, organizations, their websites, you can have patent search. Also, there are private patent search organizations called, say, for example, Patent Lanes. There are many private patent search organizations. WIPO has also a patent search device. So you go there, use few keywords around your invention and see what are the patents already people made. And you conceptualize your content around that. That is the start point. And later on, you will draft the content of the heading under called priority art. Then after, you have to write summary of your inventions, a bit about 10 sentence summary. and then a statement, clear-cut statement about the invention. And this should be followed by a detailed description of the invention, which could be 10 pages, which could be 5 pages, which could be even 2 pages. Basically, this means experiment, observations, inferences, to include figures, tables, whatever experiments you did, all to support your claims and all these things, or your observation to substantiate your observation, to fulfill your claims. You have to provide all detailed description of these things, including figure, table, chart, slide, structure, whatever it will like, you should add. And finally, you jot down claim points. Unlike in research publication, this is the only different point which we call as claim points, like bullet points 1, 2, 3, 4, 5, 6, 10, 20, 30, whatever way you would like to, you start claiming your inventions. That requires a bit of help from patent attorney so that you can frame your claim in a manner, no infringement, you are not making any infringement, and others are not allowed to make any infringement. You have to take cover about that. It is not difficult. Take it from me, none can write patent except the inventor. Even if you are a young researcher, not yet submitted your PhD, you are the right person who should start drafting the patent. In the process, you should seek help of different senior patent drafting experts. You can call me, I will help you. If any one of you have any idea, I can help you drafting the patent. And at some point of stages, you need some help in framing the claims. That's a bit of legal language. Any scientific paper does not contain much of legal language. A bit of language twisting is required in case of patent. Patent is not, drafting a patent is difficult. We tend to say there is a lot of business around going on, but it is not difficult. Take it from me. It is the inventor who can write the patent. You see first few patents around your inventions. Read the patent document completely, and you get a feel of what to write, how to write, and then you start drafting, and then you will finish your drafting. That's all, and you will get whatever you require. So nothing to worry about these things. Next slide, please. Question answer can there be? So inventor and assignee, there are two terms in a patent. The inventor, you are the inventors. 1, 2, 3, 4, who did the work actually are the inventors. Your invention is supported by your department, by your college, or West Bengal Government Research Fund, or Government of India Research Fund. So assignee in this case is your institute or government institute, research institute or college authority is the assignee. It does not mean that you will lose your ownership. You are the inventor. Most prestigious element is the inventor, and assignee is the holder or the malik of this patent. This is the website. This is one picture of an Indian Patent Office website. Next one, I have completed my talk. And next one is USPTO office. Very nice website. You need to get acquainted with these things. You can get any and every information about patent. There in each country-specific websites, their patent laws are written there. No problem. Next slide. This is the website of WIPO, where from you get many things. I will tell about one thing that WIPO, I call it. WIPO offers to young researchers. Next point. Next slide. Maybe a few examples of our patent. This is one our English patent. Same content I submitted for UK patent as well as Japan patent. We felt that it is maybe have market for that, so we did it. We got it. Next slide, please. This is another patent, basically an example of another patent. And next slide, please. Next slide, please. This is an example of another patent. Next slide, please. This slide I wanted to show you that WIPO, no, earlier slide, please, earlier slide. WIPO offers training to young researchers for patenting. This is on earlier slide, please. This is an online course. I told many of my students I took training, but later on when I was doing the patent, I came to know that WIPO gives training online. Because some 10 years back, I told 2, 3, 4, 5 of my students, but you know, some are interested. In the evenings, they used to sit, try. It's not that every time the training is on. Sometimes, somewhere, they offer some training for say limited 25 or 100 students for online training. They take online examination and they provide a wonderful online certificate also. So you can claim in your biodata that I'm WIPO trained patent learner. So that is, I must say to all young researchers, you keep trying whenever they give some online trainings like that. Last slide is thank you everyone. This is an important issue. Research must have some link with patenting arm. Come what may, it is our moral responsibility to look into this patent arm, not for myself, but for the country, but for the money provider, but for the societal benefit. So many reasons are there. Patent is worth trying and attribute, I would say. Thank you very much for permitting me to share my. Any question?
Thank you.
Thank you so very much, Professor Das, for such a lucid and comprehensive deliverance. I mean, you actually threw light on the requisites of patents, which I think is very important. And also, you know, thank you for listing the websites of patent offices. I think that will be extremely helpful for the participants present here today. Shumon, can we now go to the question answer session? Can we take a few questions?
Yeah, I'm looking the questions.
Yeah, I think Mr. Bhattacharya was about to answer the question that was asked by Professor Law. What about?
Already he explained the answer, but
Okay.
now I would like to put one question to Dr. Bhattacharya, Mr. Bhattacharya, that and also Professor Das too. So you are telling that the patent is related to the both tangible and intangible way. So as a student of anthropology, my interest goes for intangible the knowledge and the values. Whatever you are showing here, and my question is how the innocent and the rural people, that basically the indigenous people, if they have some intangible knowledge, how they are able to put this knowledge if they want to get some patent over their knowledge. So is there any way, or they have to depend on the different scientists or different researchers by which they can patent their knowledge? So this is my I don't know whether this question or not, but this is my queries regarding.
Dr. Bhattacharya, please. He knows everything.
Okay, I am Mr. Bhattacharya, not doctor. I'm sorry to say. Actually, now patent is for invention. Now, what you can patent and what you cannot, that is elaborately given in our Patent Act. Okay, in our section 2(1)(j), there are inventions which are patentable inventions. Before what we just after an application is filed, what is the task of the patent office? Patent office duty of the patent office is to examine that particular patent application and what are the criteria we are going to see or check. It should be novel, it should be inventive, and it should have industrial applicability.
Yes.
And then the section 3. Section 3 is the invention which is patentable, which is not patentable as per our act. For example, like say business method. Business method is patentable in some other countries, in US, in Japan. Their IQAC is patent act is different from our act. And like say now. Something like that is software per se, that is coming under section 3, and method of treatment, it is coming under section 3R. So these are the exclusions. And then in examination stage, we just go through that drafting of patent specification, and if there is it should be your invention, or rather any invention should be disclosed in best possible manner, so that a person who is skilled in the art, after the patent tenure is over, he can just perform without any technical help that invention for. Then it is public domain, so he can just, if he is any other party is interested in doing business with that particular invention, he can do without any kind of difficulty. That is the objective. So before applying to a patent, one has to understand that what is patentable invention and what can be patented. And there is no bar that only scientists or the persons having that very good knowledge on legal knowledge or knowledge, they can only file. Any individual, if he is capable of drafting any specification, either in English or in Hindi, here he can file on his own. Otherwise, he can take legal help also. That is optional. That is up to him.
Thank you, thank you. Now, one question from Professor Low again. To Professor Das. For low resources country or developing country without the financial capability, how could they take the advantage of a patent? Professor Das.
Can I take the first question first little bit?
Yes.
On your first question. You are an anthropologist.
Yes.
Yeah.
Please do so.
You observe
so before you're answering the question, I would like to share one of my experience. When I've been in the forest region, I would when I tried to collect the data regarding the medicinal plants.
Exactly, it is your responsibility.
Yeah. So now the indigenous people, they are very much aware that because some of the pharmaceutical companies, they already borrowed this knowledge and use this knowledge for their own, and in a particular flowing way, the pharmaceutical people, they again and again visited the particular forest and collected all the samples from the forest. So that is the important things I would like to mention. Now the indigenous people, they are very scary in order to give the informations about the different kind of intangible knowledge related to their day-to-day life.
Right. If it is not patentable, these are under short category under other intellectual property rights. Whatever I understood your concern is that it belongs to community knowledge, it belongs to traditional knowledge, it belongs to geographical indication. So you should look for it, unless otherwise it's a straightforward finding that a particular plant part is useful for treating a particular disease. This latter part was exhaustively deliberated in Indian scenario as well as in international scenario. There are many stories around that. But to start with, if it is community knowledge, your responsibility, I think, would be to consolidate that community knowledge in the form of a document. It is not a patent, but it's kind of geographical indications.
Okay. Thank you. Now the second question is Professor Low, for low resource country or developing country without the financial capabilities, how could they take advantage of a patent? Professor Das.
Professor Low, please first.
Yeah, the question she put in the chat box, that for low resource country or developing country without the financial capability, how could they take the advantage of a patent?
My perception, should I tell?
Yeah, definitely.
In case of India, there are several good quality organizations. Dr. Sanjay Bhattacharya knows it. I would refer your invention to handle with NRDC. NRDC is a very good organization who help in drafting a patent. They would not charge much if you can prove your work, prove your metal, prove your requirements. That it is a small college, it's a small investigators, young investigators found something that help in drafting the patent. There are other organizations also, including Indian Patent Office. Do not worry about this. This is available.
So actually, I would like to add something, if I am giving permission. Regarding that traditional knowledge issue, now under CSIR, a database is maintained. It is called that traditional knowledge TKDL, traditional knowledge digital library. So all the database regarding Ayurvedic, Unani, etc. are maintained there. And earlier also there was some litigation regarding Neem and Haldi. So that has been fought by Government of India. So these databases are used by other countries also. In EPO, they are having some agreement with Government of India. They are using this database. So even if a patent application is filed on this traditional knowledge in other country, they are supposed to before giving a patent, they are supposed to examine with the help of that database. They can, if it is there, then it is expected that that is also not going to be given because on the novelty ground, and that's why. So people should not be afraid. But yes, it is there. Sometimes it may be drafted in such a fashion that it may get through. But in that case also, it can be contested and patent may be revoked. And second part is regarding about an inventor who is having no resource. Okay, if he is having a patent and it is having a good market, during the prosecution stage, those who are players of that particular field, it may be multinational company or something like that, they will definitely, they are keeping a watch. Every week we are publishing our in our journal the applications filed before patent office, before examination and after before examination, all 18 months publication is there, and after grant also, grant notification is there. So they are throughout the world. It is available in our website. So digitally, it can be accessed all from any part of the world. So people, those who are the companies, they are interested in doing a business on patented product or any invention, or they can just simply it is available or accessible to them. And if any invention it is having potential, even if the applicant is not having the resource to file in PCT through PCT route, if simply he has filed application in Indian Patent Office, he can be approached and then he has to take some legal help to enter into an agreement, and from that he can earn plenty of money out of his invention.
Okay,
This
thank you.
to all
Thank you. Yeah, and one question I just is very, very important. That is why I put Professor Low question. Professor Low, I put everything a very brilliant question. That is, in evaluating research proposal, do you think we need to do a patent search, Professor Das?
If the research proposal claims that it is something commercially viable, looking like commercially viable he is trying for, then that proposal should give some references, not just research papers, but also the patents around that research proposals. No harm in it. He should divulge all those informations. What is known, I am divulging. What is my idea, I wrote in the proposal. So now you judge. It is what pursuing or not. That's the line. So patent can be given as a reference. No harm in it. Even in research paper, there are lots of examples of patents provided in the paper.
Okay.
I wrote it. I wrote it in my publication.
Thank you. Thank you. Thank you. Now, I have a question, specific question to Professor Low, that that we are always trying to, as you are the editor-in-chief of Asia-Pacific Journal of Public Health, as an editor-in-chief of a particular journal, prestigious journals, we are always looking for the ethical issues and the ethical clearance of the particular research work. Now, my question is, what are the different types of collection of consent from illiterate or contemporary illiterate or indigenous societies? So do you have any guidelines for taking the consent from that particular community? As because it is very, very controversial that whether they have understood the actual research problem, the objective, what the benefit they have, and they give their consents, right? So do you have any procedures, any category of taking the consent, ethical clearance, or consent from the indigenous population, the poor population, during the publication of the manuscript?
Yes, thank you, Dr. Suban, for a very pertinent question. Now, prior to any data collection, you do need to get a consent. That's absolutely correct. Yeah. But before you obtain a consent, you must give them this sheet, what we call the participation information sheet. Yeah. Now, in the participants information sheet, you lay down, who is doing the research, what's the objective is all about, what you expected, from them. The instrument you are using, but all has to be done in a layman language. If you are going to a tribal community, for instance, that participant's information sheet has to be in their language, all right? Whichever language, whichever community you go to. So it has to be in a layman language. So until and unless they understand the participation information sheet, and then you get them to give consent. Yeah. Now the consent, of course, people like us, we put our signature. But for them, some of them don't even know how to sign their name. So you do a thumbprint, very important. So there are different ways of collecting consent, of course. So this, I'm assuming that you're actually physically going to the village, going to the tribe community, to do a study. Okay, whereas if you are doing, let's say, in this day and age of, digital data, for instance, online survey. For instance,
you are absolutely right, Professor Low. I agreed with you. But thing is that whether the digitalized data or recording is much more appropriate for that particular issues, or rather than to write or thumb impressions.
Yes. So again, obtaining consent can be written or verbal. Yeah. So it's either you tape record them, verbally they give you the consent, or it's a written thing. Yeah. If they cannot write, then it will be best, to sort the consent verbally from them.
Thank you. Now the question, the participants put the question to was Professor Low. Professor Low already answered in the chat box. Even though I put the question, Professor Low, from Anirban Mondol. Respected madam, is it violating the copyright issue if we are copying a figure from an article with proper citation but not taking care about the permission?
Okay, that's a very pertinent question, Abida Model. Now, it's important for you, not just about citation, when you copy something, it's a full, diagram or a table or a figure, yes, it's correct that you are given the proper citation where you actually took it from, but permission needs to be obtained because the person who owns the copyright is actually the publisher, unless it's an open access journal. If it's an open access journal, you don't need to obtain permission from, the author. Okay.
Thank you very much. Now, Mitali question. I think Mitali, we have just crossed 2.5 hours. Mitali,
yes.
we have just crossed 2.5 hours. So yes, Professor Low also agreed with me that indigenous community, the intellectual property rights, we are taking away from them. Yes, definitely, and this will make our future webinar. I think Professor Low put the right track that as a student of anthropological perspectives, we are very eager to help some of the webinar based on intellectual property rights of the marginalized community, not only in India, but also in South and South Asian countries, and also the Asian countries. That's very, very important issues, and we should continue this webinar for a future perspective. Now, Mitali.
Yes, I just wanted to know, anyone, I think, of the esteemed speakers can answer this. Like when patency or copyright is being conferred, is it conferred for lifetime or for any particular period of time? If it is conferred for any particular period of time, then what is the criteria that determines the that period of time? This is what I wanted to know. Anyone who would like to answer this? Mr. Bhattacharya, maybe?
Okay, in my presentation, I have already discussed that IP right is for different category of IP, period of protection is different. For patent, it is 20 years. 20 years from the date of filing or 20 years from date of international filing. And for copyright, for different copyright, protection period is different. For literary works, it is 60 years after the death of author. Now, let me give an example. Suppose a book is written in 2020, and the author, suppose after just publication of this book or before publication, if he has expired in this year itself, then it will be further period of 60 years after his death, and during that period, right will be enjoyed by his heirs. And in throughout, suppose another situation may arise. Suppose a book is written by 3 different authors. Then it is lifetime plus 60 years. Then what will happen? Then the author who will die last from his death to 60 years. That is for literary work. But other things, for other say video recording, film, etc. For their separate timelines are there as per Copyright Act, and it is available in our website.
Thank you, Mr. Bhattacharya. Can copyrights or patency be terminated for any particular reason?
No, now any decision given by the patent of IP office, it is always appealable. Now, suppose a patent is granted or a patent is refused, it can be challenged to judiciary. Now, if it is decided by the judiciary that the decision taken given by the patent office that is not correct, then it can be terminated. Suppose if a patent right is given, then it can be terminated. Or otherwise, suppose in patent there is a provision that after just obtaining that, giving the patent right, within a 1 year one can file post-grant opposition. And there is another provision in our Act that is before the grant of the patent, at any time one can submit pre-grant opposition. In both the case, in case of pre-grant, before granting that patent application, pre-grant application has to be disposed. Suppose and in case of post-grant, after grant it can be filed within a year, and then post-grant opposition will be dealt by our office, and not that same officer who has granted that patent application. It will be given to some other officer in order to maintain that transparency, and then he can give a decision. And in case of refusal, that by patent office, that decision can be challenged to before IPAB, or if the applicant is still not satisfied, he can go to High Court or Supreme Court for further remedial measure. And in case of copyright also, if suppose the copyright application is rejected or a copyright is right is given, then someone came to know that it has been given copyright protection, but it is his copyright. It has been somehow someone is manipulating. He has got or suppression by suppression of fact. He has got the copyright. Then that can also be similar judicial procedure. He can go for a remedial measure, and ultimately judiciary is the final authority to take decide. Patent IP office is not the final authority. We are just providing the right, and in each and every case, our decision is applicable.
Thank you so very much. Thanks a million to all our esteemed speakers for showing their patience in answering all the questions. And I would now like to remind and inform all the participants who are here that the feedback form is on the chat box. So if you want, you can fill in the feedback form. Once it is properly filled and sent back to us, you will be getting your e-certificates. Before we leave this platform, may I now request Dr. Shuman Chakraborty, who is Head, Department of Anthropology, and a very, very keen member of our IQAC team. I will ask him to deliver the vote of thanks. Over to you, Shuman.
Yes, thanks, Dr. Gangopadhyay. It indeed is a great pleasure for me to give the vote of thanks on behalf of Internal Quality Assurance Cell of Miranji Datta Mahavidyapith in this international webinar on intellectual property rights, potency, design, and publication ethics. First of all, I would like to extend my gratitude and sincere thanks to our Honorable Governing Body President, Srimati Chandima Bhattacharya, for her endless encouragement to organize periodic webinar during this unprecedented pandemic crisis. Then our beloved and honorable principal sir, Dr. Apurva Kumar Bandyopadhyay, to whom we are always thankful for not only his positive encouragement, but also structural guidance to execute the webinar smoothly. For this particular webinar, we are thankful to Dr. Debashish Molli, our IQAC member and head of the Department of Chemistry in our college, who at first placed his keen proposal to organize such an important webinar on intellectual property rights, which will be helpful for our future accreditation of our institute. Then we are grateful to our today's esteemed speakers from India as well as abroad. We are extremely thankful to our inaugural speakers, Sri Sanjay Bhattacharya, Deputy Controller of Patents and Design and Head of his Department of Promotion of Industry and Internal Trade, Government of India, for his brilliant overview over patent and design and stress upon awareness in general population. Then our second speaker, Professor Yu Lo, this is the second time for her in our college, the well-known scientist and Deputy Executive Director of Research and Internationalization, Asia Europe Institute of University of Malaysia, for her specific direction regarding the publication ethics, as she has great experience to run successfully the important Journal of Public Health as Editor-in-Chief, the journal entitled Asia Pacific Journal of Public Health. Then our third invited speaker, Professor Pratap Kumar Das, though he's retired from his formal engagement for Indian Institute of Chemical Biology, but as a scientific temper, I always admire that there is no retirement from the scientific world. We are always attached to the specific work, but his thoughtful and resourceful deliberations has enriched us regarding the patent. We are extremely thankful to him. We are thankful to our all in-house and external IQAC members for their constant support to organize regular webinar under the banner of IQAC. But today, we are thankful to Dr. Dilip Kumar Mondal, IQAC member and the head of the Department of Education, who nicely introduced our first speakers. Then Sri Tushar Kanti Roy, IQAC member and head of the Department of Zoology, he introduced nicely Professor Yu Lo. Lastly, Srimati Nandini Chakraborty, she is not only the IQAC member, head of the Department of Journalism and Mass Communication, but also the esteemed governing body member of our college, for our kind introduction to Professor Pratap Kumar Das. We are thankful to all our participants for their presence and patience hearing, along with the varied questioning. We are thankful to all our teaching faculties, administrative staffs for their active involvement for betterment of this institute. We are always thankful to our IQAC coordinator, Dr. Mitali Gangopadhyay, for our constant effort in smooth organization skill and innovative direction to make not only the webinar successful, but also webinar from early lockdown stage. Above all, I would like to extend my thankful to all persons who are related to this particular webinar, and hopefully we have got the another directions to organize the future webinar related to intellectual property rights. As a student of anthropology, we are mainly interested in intangible, the indigenous people knowledge and how we are protecting, what is the way we are protecting their knowledge. That is a very, very pertinent issue in Asia and throughout the world. With this kind notes, I just thanks to all